Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
All right, let's go ahead and get started. Good afternoon, everyone. My name is Josh Pettengill. I want to welcome you to the Third Thursday webinar brought to you by Synergy Settlement Services. Every single month, we do one of these webinars on various topics that you see on a regular basis as trial attorneys. Today's focus obviously is going to be on Medicare Set Aside and this whole issue surrounding Medicare Secondary Payer compliance. It's a very hot topic right now. Among some of the other things that Synergy does and handles on a regular basis are lien resolution services, asset management, settlement consulting, pooled special needs trusts, and attorney fee deferrals. So everything that we do at Synergy is to make your life better, protect you and your clients, or make you more money, or make your clients more money. That's our sole focus, and we're very passionate about helping injury victims and doing that. Now, today, because of housekeeping items, I want you to be on the lookout for future Third Thursday webinars. Every month, like I said, we'll be doing one of these. We have a fixed schedule for the rest of the year. If you have any questions as we go through this presentation, please jot them down and email them to me. I'll promise you I will respond back within 24 hours of receiving those. So here's our plan for today. Here's our agenda. I'm going to keep things short and sweet, give you guys a background on Medicare basics. This presentation is not intended to do a full overview of Medicare set-asides, but it's important to cover some of the basics before we get into the more complex stuff. We're going to talk about the common disagreements between the plaintiff's bar and the insurance companies, and I'm going to give you some real examples that we can go through on cases that you probably see on a regular basis in your own practice. And then obviously we're going to talk about the alternatives to doing a Medicare set-aside, and there are quite a few. And then best practices for handling Medicare eligible clients. Now, how many of you have actually heard this before? You have to do a Medicare set-aside when a case resolves under the following circumstances. Number one, the plaintiff is a Medicare beneficiary and the case is settling for $25,000 or more. Or number two, the client has a reasonable expectation of being on Medicare within 30 months and the case is settling for $250,000 or more. We get this phone call probably at least a dozen times a week where a plaintiff attorney will call us up and say, Josh, I was informed by the opposing counsel that we have to do a Medicare set-aside because my client meets one of these two criteria. That is fake. That is not true. As a takeaway for this presentation, if you remember anything, you're still never required to do a Medicare set-aside. Even in workers' compensation cases, you're not required to do a Medicare set-aside. It's just become the de facto mechanism of settling cases under workers' comp. And those two thresholds that I just read to you, the $25,000 or more Medicare beneficiary current and $250,000 or more with a reasonable expectation of being on Medicare, those are workers' comp reviews thresholds. So in workers' compensation cases, in that context, if the case meets one of those two criteria, all that means is Medicare will actually take the time to review and approve a Medicare set-aside if it's submitted to them. It has nothing to do with liability cases. There are plenty of alternatives out there to satisfy Medicare's interest and protect the trust fund without doing a Medicare set-aside. The Medicare set-aside is not the end-all, be-all. And if you're taking notes, this is something you want to write down. If you have a client that's Medicare eligible, number one. Number two, there's potential for future treatment. And number three, there's actually some money there that funds future medicals. You should consider potentially doing a Medicare set-aside. I'll repeat that. Medicare eligible, potential future treatment, and number 3, there's actually money that funds future medicals. Now, starting in 1981, we were given the Medicare Secondary Payer Act. This is the law that says the Medicare Trust Fund has to be protected. It's the only law that exists on this issue, and it says anytime there's workers' comp, no fault, or liability insurance, Medicare doesn't want to be known as the primary payer. And what that means practically, if you look at this slide, Medicare is the last person that wants to pay. It's kind of like that friend or family member that we know when you go out to lunch and all of a sudden the bill comes and they're hiding underneath the table or going to the bathroom or saying they forgot their wallet. They don't want to pay if there's money available to pay for something. That's the way to look at Medicare on this issue. From their standpoint, it's almost like double dipping. If you settle a case involving future medicals for a client that gets paid on, they don't want to pay for it, bottom line. So this is a horribly busy slide, which I'm not going to go through, but again, I'll send this as a follow-up to everyone who's attending this presentation, where you can do a deeper dive into these different cases and different memorandums. So since 1981, that law has not changed at all, okay? But since 1981, we have gotten some good case law on liability Medicare set-asides. We've also gotten some policy memorandums on liability Medicare set-asides. So some of the key highlights on this are the Stalcup memo. The Stalcup memorandum was the first memo we ever got on liability cases. It says and reiterated that a Medicare set-aside is never required, okay? It also earmarked what the settlement parties' roles are for when settling liability cases. And the other memorandum that came out in late 2011 provided an actual exception when you don't have to do a Medicare set-aside. So if you have a client that does not have to treat anymore as it relates to the accident, and a treating doctor will put something on their letterhead short and sweet to that effect saying, as of today, there's no accident-related care necessary, that is the get-out-of-jail-free card from completely doing a Medicare set-aside. So just keep that in mind as we go through this. Another important case I want to mention briefly is the Benoit versus Neustrom, Benoit versus Neustrom for those that are from the South. And this was the first case that we ever received where a judge looked at all the facts of the case and apportioned out a liability Medicare set-aside and took a $300,000 Medicare set-aside and brought it all the way down to $10,000. That's also important. So what's been happening recently from CMS's standpoint? If those of you recall what happened last year, in February of 2017, we got this announcement that was issued to all the medical providers, the medical community. It stated, starting October 1st, 2017, Medicare is going to start to reject claims on the basis they should be paid out of a liability Medicare set-aside. Now, when this first came out, there was widespread panic on this issue. Everyone thought, okay, this is coming to liability cases. This is going to be officially where we have to do a Medicare set-aside, or Medicare is going to actually start rejecting claims and not paying for them. Because see, in the old days, when you settled a case, you never had to worry about your client not getting picked up for Medicare or Medicare continuing to pay. They always paid, no matter what. So I can tell you firsthand, since October 1st, 2017, we have not yet seen any type of spike or pickup in Medicare rejecting claims that are submitted to them. Does that mean it's not going to happen in the future? No. But my prediction is that towards the end of this year, we're going to have some more guidance from Medicare on the liability issue. In fact, I have very intimate knowledge that Medicare is too backed up right now to worry about this issue, yet it's still a priority for them. How much so? After October 1st, they issued another alert to everybody. I got this in an email on a Thursday afternoon. I was actually speaking at a seminar on liability Medicare set-asides when I received this in my inbox from Medicare. It said, the Centers for Medicare and Medicaid Services continue to consider expanding its voluntary Medicare set-aside arrangements review process to include liability insurance, okay? So they said, look, guys, we're still thinking about this. It's still on our radar, just so you should know. Now, they made this exact same announcement, verbatim, word for word, about it in 2016, exact. And nothing really happened in 2017, with the exception of Medicare issuing these alerts to the medical community about the potential for them to deny claims in the future. So what's happened since then is that a new workers' comp review contractor took effect and came into play in March of 2018. It's important to note because the workers' comp review contractor, again, is the entity that CMS contracts with to actually review and approve Medicare set-asides when they're submitted to them. And right now in liability cases, just so you know, even if you attempt to submit a liability MSA to CMS for their review and approval, there's a 99.9% chance that they will not review it, nor will they even respond to it. So the takeaway there is you don't ever want to make CMS approval a contingency of your settlement or term of your settlement. But going back to this new contractor, so the new contract award was for $60 million. The previous contract was for $6 million less than 5 years ago. And why the big increase in compensation for this deal? Well, many people think it's because of liability Medicare set-asides, and the threshold and the amount of cases that they're going to have to handle can be much more higher and greater than it is in workers' comp, hence the greater compensation. Now, I can tell you firsthand, knowing people on the inside who are working closely with the contractor and CMS, that this new contractor has already been a disaster. And they're very backed up, just as it stands in workers' comp. Yet, they're still plugging along, Medicare's plugging along with the idea that liability MSAs is going to be on the forefront of their issues. And in fact, when Medicare issued a draft request for this new contractor, they mentioned that liability Medicare set-aside is something that this new contractor would have to handle. So these are just all interplays of things that are happening right now. So what is a Medicare set-aside? This is the reaction I usually get when I ask somebody what a Medicare set-aside is. Next time you're at mediation for fun, turn to the person across and you ask what a Medicare set-aside is. This is the reaction you typically get. Nobody really knows what a Medicare set-aside is, but a Medicare set-aside is exactly what it sounds like. It's literally money that's set aside in a separate interest-bearing account to be used for accident-related care covered by Medicare. So an example of $5,000, let's say we were doing a $5,000 Medicare set-aside. That $5,000 would go into a separate interest-bearing account, and in a perfect world, that plaintiff, anytime they were to treat for something related to their accident, they would use that $5,000 and spend it appropriately. And it's like a deductible in the sense that once that $5,000 has been spent and spent down appropriately, they're back on Medicare's tab. Okay, Medicare has to start paying. This is only accident-related care. Medicare is going to pay all day, every day for things not related to the accident. Our focus today is things related to the accident. And why do we do a Medicare set-aside, or why should you even consider doing one? Well, a couple reasons. Protect Medicare's interest first and foremost. Protect the injury victim from potentially losing their benefits or having their benefits disrupted. And protect your law firm, clearly. You want to make sure that you educate your clients on these potential implications and document what you're doing so that they can't come back to you and say that you didn't talk to them about this. But going back to how it can impact the injury victim, so what we've seen over a span of tens of thousands of cases, before I even say what I'm going to say, it's been a very low number of denials where Medicare has actually refused to pay for something, and or they've come back and said, you know what, we made a mistake and shouldn't have paid this, and now you owe us money for it, post-settlement. I can tell you over the last 10 years, the number of times we've seen this happen is probably less than 24 times. And the thought with the announcements going back to 2017 was that we were going to see a bump in the increase in denials. That has not happened yet, as I mentioned before. Now, as an attorney, how do you know when your clients are actually going to be eligible for Medicare? Here are the reasons. If you have a client that's age 65, they can be eligible for Medicare. If you have a client that's receiving Social Security disability benefits for a period of 24 months, they also become Medicare eligible. End-stage renal disease, we've had a lot of these cases recently where one of our plaintiffs' clients has had end-stage renal disease that automatically qualify for Medicare. Lou Gehrig's disease, or a child is disabled with a deceased parent or disabled parent. Very few and far between do we have minors that are doing Medicare set-asides. Typically, it's for an end-stage renal disease situation. But there are cases where there may be a car accident situation where many family members were injured, and through the path of the parent, the child does become eligible for Medicare. So just something to think about. Number one, Medicare eligible. Number two, we're talking about the criteria for when you need to consider doing something as far as addressing the future issues. Is there future treatment or medicals claimed in the case? Okay. Number one, Medicare eligible. Number two, is there future treatment potentially necessary? And number three, is there actually some money there that funds future medical? Now, arguably, there are situations when you may receive a full policy limit case or get a very nice recovery for your client, but yet there's no money left over to fund future medicals. So if there's no money left over to fund future medicals, there's nothing that can be set aside. And there's actually case law to support that methodology. That previous slide had the name of the case, it's Starrett versus Klabart, where a judge looked at the facts of a case of a paraplegic who settled their case for, I believe, $650,000. But when the dust settled, when the liens were taken into account, procurement costs, the wife's claim, the judge said, look, there's no money here. There's no need to do a Medicare set aside. So just something to think about in your own caseload. So what are some of the problems that we see all the time here at Synergy as far as fielding phone calls and case inquiries? Problem number one, there's a tremendous amount of misinformation in the marketplace about this issue. And when I say that more apt to the insurance companies, that they've been so badly misinformed by whoever's advising them on these issues that they think it's their business. They think it's their business. The Medicare Set Aside issue somehow is going to some way impact them if they don't address it. I'm here to tell you that this is a plaintiff issue, okay? I'm going to repeat it. The worst thing that can happen is nothing gets set aside. The client goes to treat and Medicare denies something, and that client comes back to you and says, hey, wait a minute, why don't you tell me about this issue? It does not impact the defendant in any way, shape, or form. Now, as it relates to conditional payments, everybody has got skin in the game on conditional payments, all the settlement parties, okay? But it's important that you control that piece of it too and start early and saying, look, we're going to control the conditional payment side and resolving that. And obviously, Synergy works all the time. We have a whole office building of people that do nothing but deal with Medicare lien resolution. It's important for you to take control of the conditional payment side, even though it does impact the defendants. So the defense job on these cases, when you're settling a case involving a Medicare beneficiary, their job, their responsibility is to report that case under what's called the Section 111 mandatory reporting requirement, okay? So anytime you're resolving a case involving a Medicare beneficiary, that defendant or carrier is supposed to be reporting that claim to Medicare. That is their job, okay? So the futures obligation, Medicare stated this in their policy memorandums, that it's up to the plaintiff's attorney to decide whether or not future medicals are funded, and if they are, how is the Medicare trust fund going to be protected? So the takeaway from this slide is that do not let the insurance company dictate the terms of not only just the conditional payments, but also the Medicare Set Aside issue, more importantly. The other thing that we see is the carriers are holding the checks hostage. Before I get into that, I glossed over a slide. And some of you may have said in other presentations and heard the story, but the only risk that exists on the plaintiff attorney side is, again, failing to advise your client on the potential implications for denial or for some type of repayment that's owed to Medicare. A few years ago, I received a call from a law firm down south that said, Josh, you have to come meet with my firm right away. I settled this case 2 years ago for $80,000, and now my client is getting denied for surgery from Medicare, and now they're threatening to sue me. That's the first time I'd ever seen that firsthand that an attorney was actually getting threatened by a legal malpractice case. Ever. I've never seen it, but it's the first time it's happened. So that risk does exist. Problem two, again, holding the checks hostage. I can't tell you how many times that my partners and I have been involved on a case where you think the case is headed towards the finish line, and all of a sudden a release is dropped in your lap. And not only is a release dropped in your lap, but it also, an MSA report is dropped in your lap that was never discussed. It becomes a huge problem because now all of a sudden you as the trial attorney are scrambling to address the issue at the 11th hour. You have a client that wants their money. You have a client who's got an expectation of getting a certain amount of money in their pocket, but now all of a sudden this curveball is thrown at them once you've already settled the case. And that what's happening is because they're cutting the checks, what I'm starting to see is that they're trying to call the shots. Like they try to call the shots on the conditional payment side, they're trying to call the shots on the Medicare Set Aside issue. The problem is most of the time when they're doing this, and Medicare Set Aside is not appropriate or maybe not even applicable to the case. The other thing that I'm seeing in relation to the problems are the carriers are so used to doing Medicare set-asides in workers' comp contexts. So a lot of these large liability carriers, they also do workers' comp. So this Medicare set-aside issue really stems from the workers' comp industry, okay? The problem with that is that workers' comp is a completely different animal than liability cases, as we all know for those that practice liability. And this slide really sums it up. This is the typical carrier's position on a liability case. They're trying to jam a square peg into a circular hole. It just is not going to work. It's a recipe for disaster. Why is it a problem? What we're seeing now, not only on large 7-figure, 8-figure settlements, but even on what I call cases that keep the lights on, bread and butter cases, $15,000, $25,000, $50,000, $35,000 settlements, where when you get a release, guess what? They give you a release, a general release, but then they're hitting you with a Medicare addendum or 10 pages of Medicare indemnification language. And these are the options that they're giving you. They're saying, look, your client is going to agree to do a Medicare set-aside, or they're going to get a letter from the doctor saying there's no future care necessary. Sometimes they'll actually include a third option where they'll allow the plaintiff to sign off saying that they're not going to bill Medicare for any future related care going forward, which again is handcuffing the client, in essence saying, look, you're taking this money, you're not going to bill Medicare. You don't want your client ever sign off on any of these things, okay? I have a case right now where it's having to go before the judge ultimately because there's a disagreement on this issue. And the last resort when there's a disagreement between the plaintiff side and the insurance side is to go before a judge. Now, CMS will certainly respect the opinion of a judge. They've even said that. And we've had to go before courts on many different occasions to have the judge actually bless the Medicare set-aside amount and or bless the reason for not doing a Medicare set-aside. And again, you don't ever want to do that. That's almost a nuclear option, but it is there in your back pocket if you have to get a motion to enforce a settlement. The takeaway here is that, again, you don't ever want to make one of these three conditions an element to your case. Because sometimes there are situations where their criterion cannot be met. They're saying, look, you have to do this before we cut a check. And one of those things they're trying to get the plaintiff to do is not possible. So maybe they're laying out three different options, but only one of them is a viable option. So what are the carriers missing on this issues? On liability cases, what they don't take into account, and even their experts that they're bringing in, their quote-unquote Medicare specialists that they bring in, they're so accustomed to doing comp. They're getting scared to death by these Medicare vendors. They're talking in their ears saying you have exposure for not addressing this issue on the insurance side if you don't handle the Medicare set-aside issue. Oh, by the way, if you're going to do a Medicare set-aside, you should base it on the workers' comp methodology, which is flawed. Why is it flawed? And I'm proud to say that over the years, we've lobbied tirelessly in conjunction with AAJ, countless other trial groups, and directly in front of CMS's face saying, this liability MSA issue is one that you don't want to touch. You don't know how to deal with it. If you did know how to deal with it, you would have figured it out a long time ago. They just can't wrap their arms around the concept of procurement costs, the concept of caps on damages, policy limit cases. There's not a one-size-fits-all approach. But these are the things that you want to take into account. And if you're going to do a Medicare set-aside, these things have to be taken into account. Because ultimately, if you elect to do a Medicare set-aside for your client, the question becomes, once that case settles, how do we carve out the lowest possible number that we can come up with that protects everybody? Okay, and this is what the insurance companies are not doing. And it's becoming a fight almost on every single catastrophic case because they're so concerned about the issues. I talked about the Medicare release language, and I'm going to show you some sample verbiage that we see frequently that you cannot agree to under any circumstances. Now, Section 111 mandatory reporting addendum is something that most of you on this call have probably started to see. If you haven't seen it, you're 1,000% going to see it. So if you have a case involving a Medicare beneficiary, or even a case not involving a Medicare beneficiary. You may get the request from the other side saying, we need your client's information, their date of birth, we need their social security number, we need to check off that they have future treatment, what are the ICD codes. All of this information gets reported by the defendant, what we call the responsible reporting entities. Going back a few slides ago, we said, look, it's the defendant's job to report the case. So they're so paranoid about not reporting the case, and there's a reason for that, because they can be fined up to $1,000 per day for failing to report that case in a timely fashion. Here's some typical examples about release provisions. And I'm not going to read all of these to you, but you can see here on the screen, all of these handcuff your client for the most part. And the last thing you want to do is have your client be handcuffed. And another thing that we're seeing on a regular basis is not only is the plaintiff having to sign off on a release language, addendum language like this, but they're also putting a signature line for the plaintiff attorney to also sign off. And there's verbiage in the release that's saying, putting it back on the plaintiff's attorney as a responsible person for the Medicare Set Aside issue, not the plaintiff themselves. Don't agree to it. Talked about the penalty notices. They're scared to death of Medicare. The fact is, and its reality is, the insurance companies, they do have the deep pockets, okay? And if they fail to report the case in a timely fashion, they can be fined up to $1,000 a day. Now, Medicare hasn't really been enforcing these penalties, but they're going to start doing that. But the threat of that is always looming, and that's why insurance companies are so scared of Medicare. Okay, I want to talk about a brief case example. Meet Grandpa Jones. Grandpa Jones has been married for a long time. He worked for 45 years as an engineer for Pratt & Whitney, likes to play golf with his buds on the weekend, occasionally likes to mix it up and play some poker. One night he's out in the town having a good time after a round of golf, playing some poker. He falls down the stairs, slip and fall case. He was intoxicated partly, so there was some liability and coverage issues. He settled the case for $100,000. Okay, so obviously he's 75 years old. There's a lien there, so Medicare has made payments on this case. There's a future surgery recommended of $15,000, going to at a cost that a doctor has told us was going to cost $15,000, and some possible therapy as well. And the net to the client is going to be about $45,000. So this is a prototypical example where we get the call, Josh, I've got a slip and fall case. Maybe it's a $50,000 settlement. Maybe it's a $100,000 settlement. Maybe there's a surgery that's recommended that the client's never going to have. Okay, maybe throughout the course of that case, the hip, knee, neck, all of it was being claimed as part of the settlement. But once the case settled, ultimately it was just the back. Why is this important? On certain situations like this, if you asked 5 different Medicare specialists what the correct approach would be on this case example, you'd probably get 5 different answers. I get those calls as well. Josh, I called somebody before I called you. Here's what they told me. Most recently, this example, one of our attorneys was told not only that they have to do a Medicare set aside, they have to submit it for Medicare's review and approval when the client's walking away with less than $50,000. Now that is asinine. It's asinine because, number one, it's a cost that the client has to bear to do that report. Number two, there's never a chance that Medicare is going to review a case, in all likelihood, if it's submitted to them. And number three, in all reality, this client is not going to have to treat in the future. And that's where it becomes a double-edged sword. Oftentimes we see there's a surgery recommended which helps get the case settled for a good number. But then ultimately on the back end, we're saying, okay, you know what? The client's is done treating, not going to have that surgery. So what happens practically is that those ICD codes get reported by the defendant in these situations. Before I go there, on a case like this, one thing you could do in abundance of caution would be just to simply advise your client, look, if you're going to have a surgery, set aside the $15,000. In all likelihood, Medicare is going to continue to pay for your therapy if you need it, as it stands today. But if they come back and say, you know what, we made a mistake and shouldn't pay for the therapy, or if they try to deny something in the future, you have that $15,000 set aside. Now, is there a formal report that's going along with that? Absolutely not in this situation. Can a document be signed that says, look, the client has understood their obligations and is elected to self-administer an account for $15,000? Absolutely. The rule is not to just do a formal Medicare set aside and get a report. The only rule that exists that the Medicare trust fund has to be protected. Okay, so ICD codes are important. Right now, there's over 140,000 ICD codes. Some of you may have seen Tom Brady last week. There was some big function up in New York City where he dressed kind of oddly. And R46.1 is an actual ICD code. Here's a picture of a lizard. Struck by a non-venomous lizard, initial encounter. These are real ICD codes that exist. The point is, and the takeaway here is that the defendant is going to report something to Medicare, those ICD codes. They have to. Here's a snapshot of an actual reporting screen where when they go to report that case, they have to include an ICD code. So what can happen down the road is if an ICD code gets reported, Medicare could potentially deny something for that body part. So what you don't want to happen is the wrong ICD code gets reported, and now all of a sudden Medicare is trying to deny something for something they should be paying for. Okay? We've seen that happen. And why is it important? There's something called a Medicare Common Working File, and no one ever talks about this. So anytime someone becomes eligible for Medicare, this Common Working File is established, and all of their beneficiary and benefits information goes into that Common Working File. Okay. Now, as part of that Common Working File, the Section 111 reporting data also goes into that file. Okay. So I spoke at a conference last year where there was a head honcho at CMS, a guy named John Albert, said 97% of what Medicare tracks comes directly from the reporting requirement, which is scary because you as plaintiff attorneys, for those of you that are plaintiff attorneys, a lot of times don't know what's getting reported to the Medicare by the defendants. So you have a responsibility to your client to ask that information. Now, they're not required to give it to you, just like you're not required to give them your client's basic information for them to be able to report the case. The takeaway there is there's got to be communications. And when in doubt on what the ICD codes are, you can actually list the ICD codes in the release. I have some clients now that are actually putting the ICD codes in the mediation agreement. The more touch points as far as documenting the file, the better. Okay. I want to get into the alternatives to a Medicare set aside. So the fundamental issue about this is Medicare going to have to pay as a result of this case resolving? In other words, is there going to be a shift in burden to Medicare to pay as a result of this settlement? You have to ask yourself that when you're settling a case. Now, there are a lot of situations where you may have a client that has private health insurance, whether they get it through their spouse, whether they get it through some pension program or some benefits, retirement benefits they get. There are some types of health insurance that last indefinitely. Okay, we have a lot of clients that have had governmental jobs where they have, or they're a police officer or whatever they are, a teacher, where when they retire, they don't ever lose their health insurance benefits. Okay. And what that means practically, even if they are Medicare eligible, as long as that health insurance coverage is maintained, there's never going to be a shift, again, to Medicare to pay that bill. Okay. From Medicare's standpoint, the trigger point for them is if they get a bill from a doctor and they tie it back to the Common Working File and the reporting, it matches up to the ICD code, that could trigger a denial. But if they're never getting a bill, that's never going to happen. So from Medicare's standpoint, they've also told us by way of the reference guide what happens when there is private health insurance. In Medicare's world, they don't care about that. They say there is the possibility that the client can lose that health insurance. Medicare doesn't live in the real world because there are situations when the client will not ever lose their health insurance benefits. And as long as you document your file, again, that you've explained the issues, have your client sign off on something, they're going to be okay, meaning there's never going to be that possibility for denial of care. Now, some of our clients are on Medicare Advantage plans. In fact, as it stands today, the number of Medicare Advantage enrollees goes up every single year. It's more than a third, well over a third of the population is our Medicare Advantage plans. Those are also private health insurance plans in the sense that they're handled by private entities like Blue Cross Blue Shield, United Healthcare, Cigna. they're processed. Those bills are processed through private entities. I want to make a note here, and there's a takeaway here for this case example. With the Medicare Advantage plan, as of today, we, all of us have never seen, over a span of tens of thousands of cases, Medicare ever deny something on a Medicare Advantage plan. When I say Medicare, a Medicare Advantage provider ever denies something, as long as the lien has been paid back, they've continued to pay for our clients. Now, going forward, Medicare has said, look, we're sharing the common working file with our Medicare Advantage contractors, so they will have the ability to deny something if they want to in the future. Now, there's a lot of case law that exists on Medicare Advantage plans on conditional payment side, and arguably they're saying they have the same rights of recovery as Medicare, traditional Medicare. So there's no case law that exists on the futures issue as it relates to Medicare Advantage plans, but I hate to say that I think there's going to be a provider this year or next year, the next 24 months, that's going to try to make a stand on the futures issues. It's going to happen. It's probably going to be Humana, because Humana has been leading the charge on collecting on the past stuff. But the takeaway there is, talk to your client. If they have a Medicare Advantage plan, let them understand, in all likelihood, Medicare is going to continue to pay. But if they switch back to traditional Medicare, those bills will be going directly to Medicare, which again could trigger an audit or denial. Some of our clients say, Josh, you know what? I'm just going to pay out of pocket as I go. I'm not going to set aside anything, but I'm still going to pay for this treatment if I have to treat. And that's okay too, because again, there's no shift to Medicare. Those bills aren't getting shifted if they're getting paid directly by the client. The issue with this is that if a plaintiff says they're going to pay out of pocket as they go, it could end up costing them a lot of money. If the care goes south, or if their condition goes south, they might have been paying a lot more money out of pocket rather than having to just set aside a Medicare set aside in the front end. Let me repeat that. So when a Medicare set aside is done, it's simply a good faith estimate based on all the facts that we know about the case, okay? And that number is set aside at the onset of settlement. It's a good faith estimate. Let's say it's $5,000. If that client says, I want to set aside the $5,000, I'm going to pay as I go. If they do it that way, it may end up costing them $10,000. Rather, they could have just set aside $5,000 in the front end and be done with it as an insurance policy. Medical savings account is something that can be done. Settlement preservation trust is another one. Oftentimes, we have clients that set up trusts, and we have clients that actually set up preservation trusts to make sure, obviously, that their assets are protected, but also designate payments to be used for future treatment if necessary. And right now, the whole system is in flux. They're talking about Medicare for all. You know, the Obama coverage is in limbo. Those are options right now for our clients. Okay, using a structured settlement to designate for future all medical care. A lot of times we have structured settlements involved with our catastrophic cases. Okay, a structured settlement is simply a periodic payment for life or some period of time is guaranteed by an insurance company. And a structure is a great tool because it's no cost to set it up, obviously. It's guaranteed. It's tax-free. And we have some clients, I'll give you an example of a case recently where there was a workers' comp component of the case and a liability case. And the liability case was able to resolve, but the comp had a lien that had to be paid back, and the comp benefits were going to remain open. In that situation, what happens is the plaintiff is going to be on the hook for a percentage of his or her medical care going forward. So the structured settlement can act as a de facto Medicare set aside in that situation to pay for any medical care going forward. That way, if comp ever settles that claim in a situation like that, if you have a comp and liability case, ultimately it's going to fall back on the comp to do a Medicare set aside when that case ultimately does resolve. But a structured settlement is a great way to protect Medicare's interests and make sure your client's protected. I want to give you a few more case examples. Recently, we received a call from a Minnesota attorney where he had clients who were out to dinner, and on the way home, they got hit by a drunk driver, and both of them became paraplegics, husband and wife couple. Very sad case. And there was a limited policy of $500,000, giant liens, Tons of future treatment going forward that's going to be recommended. And when the dust settled on the case, they were only going to net about $100,000. This is a perfect example of a situation where a Medicare set aside should not even be thought about because there's no money there to set aside. Now, if you talk to other Medicare set aside experts, they'll say spend a couple $1,000 to get a report done and set aside a big chunk of money. They can't do that because it's going to be, in all likelihood, the Medicare set aside number for either one of them is going to be much, much higher than what they're going to net in their pocket. And then what happens? I talked about this comp liability situation. Now, what are best practices for you as trial attorneys? You got to start early on these issues. You can't wait till the last hour to address it. I see it too often where nothing gets discussed and all of a sudden we're sitting around a mediation room and client says, oh, I got my Medicare card last week. Oh, and by the way, I used it. And now everybody's scrambling on the issue, and it almost becomes a separate mediation to resolve the Medicare piece of it. You got to be able to identify these Medicare beneficiaries early on in the process. Going back to that early slide, there are a lot of situations where your clients, and they're not 65, when they're going to be eligible for Medicare. Now, I'm sure a lot of you are doing this now and getting copies of all health insurance cards and copies of governmental programs that your clients may be on, but there is a form that we can provide to you that you can stick in your file, a Social Security form that they can take to their local Social Security office, where they'll give them in 15 minutes a printout of all the benefits that they're entitled to for Medicare, Medicaid, SSI, SSDI, date of entitlement, all those things. You need to put that document in your file because you can also do that on behalf of your clients, not just let them do that for you, because it will never get done probably if you're relying on them to obtain that information. As a takeaway, we will send that around after this presentation. I've said this so many times, but it bears repeating. You've got to start communicating early and communicating often on the Medicare issue. You can't wait until the last minute to decide, number one, do we need to do anything about the Medicare issue? And number two, if we're going to do something, what are we going to do? Are we going to do a structured settlement? Does the client have health insurance? Is the client done with their treatment? Are we going to do a Medicare set aside? These things can't be a discussion at the 11th hour. And these are the issues that have to be discussed. The conditional payments, Section 111 reporting data, Medicare eligibility, and release language is vitally important. So your litmus test as a plaintiff trial attorney is, number one, is your plaintiff eligible for Medicare benefits? Number two, is there accident-related care? And number three, does it fund future medicals? That is your litmus test. If the answer is no to any of those, Synergy can actually, as a brief commercial, can do a no MSA letter for your file. It says, for these circumstances, based on these reasons, there's no need to consider doing a Medicare set aside. Like I said, there are situations where maybe a client is done treating, or maybe there's no funding of future medicals, or maybe there's no eligibility for Medicare. And a lot of you have started to see these requests going back to Section 111 data reporting requirement about your client. And more often than not, you may have a client that's not even going to be eligible for Medicare, yet they're trying to force the issue down your throat. We can do a no MSA letter for your file. You got to come up with a system, internal system with your staff, and identifying these cases and determining if future medicals are going to be funded. And then ultimately, it comes down to how are you documenting your file. The more touch points in your file, the better. As long as you can justify what you're doing or not doing, that's what matters the most. Now, is that going to hold up from Medicare's standpoint? We don't know, but it's certainly better than doing nothing. You have to document your file. You have to educate your clients on these potential risks of not doing anything. Now, a lot of you have your clients sign off on a waiver that covers everything under the sun, and that's okay, but you may want to consider getting a little more detailed as far as having a separate internal document that they sign that says they understand what the potential implications that Medicare could deny something, and they've elected not to do anything, or they've just decided not to do anything for whatever the reasons are, but have them sign off on that, okay? And document what the solution was that they're using. So for us, we have a tiered approach as experts. We see probably more catastrophic and complex cases than anyone in the country, and it's a tiered process. But if we're actually going to do a Medicare set aside, on our end for our clients, going back to how do we get the most money for our clients and how do we protect them, our job becomes post-settlement. How do we completely eliminate the need to do a Medicare set aside, or if we're going to do a Medicare set aside, how do we grind out in the lowest MSA possible that's going to protect everyone's interest? Same goes if we're not doing a Medicare set aside. How are we going to make sure, if we're not doing a set aside, that we document what we're doing and make sure that no one's going to get in trouble or benefits are going to be disrupted? That's where we come into play. So going back to actually doing a Medicare set aside, if you have a catastrophic case or maybe a case that meets all three of those criteria we talked about so often today, and you want to actually do a Medicare set aside, what we're going to request from you is the medical records. It's going to be based on a review of the medical records. Medicare allows us to use what's called a rated age, which is a substandard life expectancy assigned to an individual. So someone that's catastrophically injured, let's say, for example, you have a 50-year-old, healthy 50-year-old, they may have a life expectancy of 30 years. But that same 50-year-old who's a quad may have the life expectancy of a 75-year-old. Well, Medicare allows us to use a rated age, which is important because the lower the life expectancy for purpose of the MSA, the lower the number is going to be. Again, an issue that a lot of these insurance companies do not understand. Apportionment is huge. Arguably every single case that you settle on a liability claim, you're never getting 100% of that case value. Anytime, even if you hit a grand slam at trial, there's going to be procurement costs. There's going to be fees, liens, costs, everything. Your client is not ever being compensated fully. So we can probably make the argument that there's cause and there's reasoning and just cause for apportioning out the MSA figure. So a lot of times what we're doing is we may have initial number prepared based on review of the medical records, but once the dust settles, the case is resolved. When we look at the big picture of the case, maybe there's a $25 million life care plan, but the client's only walking away with $5 million in their pocket. We can apportion out the MSA accordingly. And there's case law to support that methodology. Some of the things the insurance companies are doing that is not correct is that they're pricing these things the way they price workers' comp MSAs. And they're overinflating their numbers. So the predicament, if you believe it or not, is that we're starting to see is that there are dueling MSAs. We get down to the finish line, all of a sudden the plaintiff has an MSA, the carrier says, oh, now we got to get our own MSA. And ironically, oftentimes the insurance company's Medicare Set Aside is much higher than the plaintiff's MSA, which is funny because obviously before the case settles, they're saying the case is worth a heck of a lot less. But now when the case resolves, they're saying, oh, no, your client, Mr. or Mrs. Attorney, has to set aside more money than what your own expert thinks, which is asinine. So if you're going to do an MSA, the good news is we're able to control that process more often than not and say, look, get them to understand this is a plaintiff issue. This is a good faith estimate. Maybe we're not doing a formal report to justify the numbers, but we're setting aside something. It's better than nothing. Maybe we're doing one of these other things that we talked about. That's clearly protecting Medicare's interests. The takeaway here is that if you look at the numbers for last year, we were able to really reduce these MSA figures substantially, which means more money in your clients' pockets, which means, obviously happier clients as a result of that, but also more importantly, they're going to be protected from Medicare. Here's our tiered approach. The MSA evaluation letter is something a lot of our clients use on cases as low as $15,000. They say, Josh, I've got a Medicare client, but I want to make sure we put something in the file that we document in our file. I want to get this letter done. We'll do those all day. And not every time is it going to come back that we don't recommend an MSA. Of course, if the criteria is met, those three criteria we harped upon, the letter is going to state an MSA analysis should be considered because that's the agency's preferred mechanism. So a takeaway from this presentation is there are alternatives to an MSA, but the MSA is still the agency's, Medicare's preferred mechanism of protecting the trust fund. But the evaluation letter could be a good starting point for a lot of your cases and any point. The second tier of services that we offer is a consultation and waiver for $500, where an expert will come talk to your client by phone, by WebEx, in person, and lay out the options for them and let them make a decision as to what they want to do. And when we talk to these people, it's not a scared decision that they're making. We say, look, here's reality. The reality is Medicare has done nothing on this issue. In all likelihood, Medicare is going to continue to pay, right? But if you want an insurance policy, you can set aside some money. It's always your money. You can go down to your local bank, get a debit card inside that account. And if Medicare ever comes back down the road, well, guess what? You have money set aside. And oh, by the way, if Medicare gives you a bill later down the road, you're going to have to get to pay them back and get the benefit of the Medicare allowable rate. Now, clearly, best practices, if they're going to do a set aside, is to use the money immediately. But again, living in the real world and being practical about it, they could take the wait and see approach and say, okay, I'm going to set this money aside, and I've got it there. It's always my money if I need to dip into it for whatever reason. But if we got the report done, we got the number set aside, the most they're ever going to have to pay out of pocket is still that number that they've set aside, elected to set aside. Important to note. But the consultation allows them to make that decision. If they say, Josh, thanks, but no thanks, I don't want to do anything, we put together a very comprehensive waiver for them to sign, saying you, the trial attorney, recommended they address the issue and properly consider the issue. You brought in a third-party board-certified Medicare Set Aside consultant to explain the issues, and they elected on their own not to do anything. Now, is that going to hold weight with Medicare? God only knows, but it's better than doing nothing. It's a 15-page signed affidavit that the client's signing that they said, I don't want to do anything right now on this issue. Put that in your file, go on to the next case. Finally, the full allocation is the best compliance solution for the right case. By doing a Medicare set aside, that's the due diligence to support what was done. So the difference, I highlight these differences. So some clients say, Josh, you know what, I'm just going to set aside, I'm going to pick a number, set it aside. Maybe it's $5,000, set it aside, and go with that number, which is fine. Again, it's better than doing nothing. But if there's a report to support the documented number, that's going to always hold weight with Medicare. It's best practices that Medicare can never come back and say, you didn't set aside enough money, because the due diligence is behind it. And we take on that liability. With all these services, you're shifting that liability to a third party. And these are all costs that your clients would pay. It doesn't come out of your pocket, because just like any other expert, these are costs that they pay ultimately. But it's for their own benefit. Either we're getting them more money or they're making sure they're protected. But that Medicare Set Aside report, again, is the due diligence. It shows that what we've done, they keep that in their file, and you can close your file and go on the next case. Now, we do a lot of complimentary CLE training for your law firm. We've covered a lot in a short amount of time today. We could do literally 2 weeks on Medicare set-asides. But if you want us to come to your firm and do a complimentary CLE, we'll feed you a nice meal, nice hot meal, and also you'll earn CLE credits. But we can also do a deeper dive into some of these issues, or if you want to break off some of these issues that we didn't get a chance to deep dive into, we can do that. And not only do we do complimentary CLEs on Medicare set-aside issues, we do them for everything. We do them for lien resolution, whether it be hospital liens, ERISA liens, private liens. You know, Synergy does all those liens. And just to give you, again, a brief commercial, if you want to engage us for lien resolution services, you could start from the get-go or hand it off to us after you've already tried to negotiate that case. We're only going to take a fee if we're able to do better. So we're never going to take a fee if we can't get any greater refund for your client. So in that sense, it's a free roll. We actually have, we call it the Pepsi Challenge, where we've had clients who have brought in other experts prior to us, and we say, throw it over to us after you brought in an expert. You want to try us for the first time, and we'll get you a better result. We've done that. We've had a case in California recently where conditional payment was the amount of close to $1 million, and this other firm was working on the lien for 6 months. They got it down to a certain number. Case was done. They were getting ready to pay the risk lien off. They called us about the Medicare set-aside issue. We said we can handle it all. We'll do the Medicare set-aside for you. But oh, by the way, let us take a shot at this, the risk lien. And we knocked off another $100,000 off their final number. Just one of many examples. But call us all the time. Call us on these issues. At some point, you're going to have to engage us. We want to earn your business. Clearly, we're very passionate about helping others. Everybody in the firm of Synergy, down to all staff, is passionate about helping injury victims. I can't tell you how often that we send these little emails around firm-wide celebrating these victories of getting more money for our clients, protecting our clients, sending around pictures and notes, handwritten notes. You know, that's what we do. We're all passionate. We love. That's what we do. So call us. When you're in mediation, don't wait till your mediation to call us, obviously, but we can do that as well. My partner, Dave Place, is our Director of Lien Resolution. I call him all the time for mediation. and he's there available on his cell phone. We're all available on our cell phone. All right, let's wrap this up. Here's an acronym for you for Synergy. If you remember anything about Medicare secondary payer compliance, here it is. Start early in identifying Medicare beneficiaries. Why? You control the process. Don't let the other side control the process. Because once you lose control of that, the case may never end until you end up in court to get a motion to approve the settlement. Never rely on the opposing side's experts. If you're in a situation where the insurance company says, oh, you know what, we'll take care of the Medicare set aside, you cannot rely on that. Okay, that's the equivalent of you relying on the expert of the defendants for a life care plan. You would never do that. Same goes for Medicare set aside or an MSA opinion. You don't ever want to rely on the defendant's expert. You want to rely on your own experts who know these issues. Educate your clients on the potential risks of not doing anything. Right now, those risks are still very, very, very low, and we tell them that. But it's still a risk nonetheless. Now, going forward, is that uptick going to increase in denials? I hope not, but I think we may start to see some things. We may get some case law this year for denials. We don't know, but just educate them and then document it. Retain your own experts. Go on the offensive. That goes for not only the traditional Medicare issues, but also the Medicare Advantage plans. Most of our clients we talked about are on Medicare Advantage plans these days, and you may have a situation where you're checking the final demand with Medicare may be a zero balance, but oh, by the way, someone paid that bill. In all likelihood, there's probably a Medicare Advantage plan. You can't ignore that. And it's important to note also, you may have clients that have just become eligible for Medicare, and Medicare may have a zero balance, okay? But that case is still going to get reported to Medicare, which could trigger denial in the future. So even if Medicare has paid nothing, or they said they paid nothing, you still have to be concerned a little bit about this futures issue, okay? And oh, by the way, Medicare does make mistakes for the good of our clients. If you get a final demand from Medicare and it shows a certain number and you think it's much higher, you pay that off. They can't come back to you and say, oh, we made a mistake and our final demand is a different number. You pay that number off and you pay it quickly. Documenting your file, at the end of the day, it really comes down to documenting your file, regardless of what you decide to do or not do. I've hammered this issue today. The more touch points in the file, the better, whether it be in your closing statement, your mediation agreement, your release language, all of the above. You got to document your file, what you've done. And the final takeaway is, again, there's nothing out there that exists as you have to do a Medicare set aside. And until CMS comes out with further guidance, you just have to stay in front of this issue and be proactive in identifying these cases, because you don't want to get stuck in that same situation where all of a sudden you've got a great settlement for your client and now everyone's scrambling on this Medicare issue, or now all of a sudden your case is being held up. You don't want that to happen. I want to thank everybody for sitting through this presentation. We covered a lot in a short amount of time. Please email me. My email address is right here. We're always there for questions and CLEs. And with that, I will shut this down. Have a great rest of the week, everybody. Thank you.